Guilty or not guilty?
I'm saying
period. I'm
that's
about
saying
to
that
set
I'm
your
not.
case for
That's
trial.
saying that I'm not. That's basically saying that I'm
We're not going to
guilty
argue the
or
law.
I'm not, or I'm guilty.
We're not arguing
That's
the law.
basically just saying that I
Doesn't-
state that.
I'm not going to
Go
argue
ahead.
the law
Fine,
with
no
you.
guilty.
I'm not playing games, and I'm not going to accept the disrespect. I understand that you're already doing time for a murder and that you don't really care about what's going on today.
I'm saying I plead no contest because he never even went over the indictment with me.
Yeah.
I find that hard to believe. So here's going to show disrespect while we're doing it to me. Do you understand?
Before a simple guilty or not guilty can even be answered, this courtroom explodes into a heated legal showdown. What should have been a routine plea hearing quickly becomes a battle between a judge trying to maintain control and a defendant refusing to back down. Victor Charles Campbell Jr., already serving time for murder, faces new felony charges and a major decision: accept an 18-year plea deal or risk a much harsher sentence that could reach 25 years to life. As tensions rise, legal arguments, frustration, and a shocking moment of sarcasm push the courtroom to its breaking point. Stay until the end, because this case takes several unexpected turns.
Good morning. Are you Victor Charles Campbell Jr.?
Yep.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
Well, you are.
And it looks like we are going in 21-36426 and 22-39050, correct?
There's also a dismissal in 3059.
And are we going on all of the counts or
No, not on. We need to go on. Well, in 36426, he will need to be true to the one enhancement paragraph in the indictment,
okay.
and yeah, one only in the other. Right.
All right, Mr. Campbell. In cause number 21-36426, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from November 28th of 2020. The indictment further alleges that you were previously convicted of assault family violence, a third-degree felony, December 5th of 2014. And how do you plead to that charge?
Say that again.
So to the charge, let's start with just evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty? It's guilty or not guilty. Either you did it or you didn't do it.
I thought that's what the plea was.
There's a plea agreement means in my court, you either enter a plea of guilty or not guilty.
Guilty. But
Mr. Campbell, I understand that you're already doing time for a murder and that you don't really care about what's going on today.
I'm saying I plead no contest because he never even went over the indictment with me.
Yeah.
I find that hard to believe.
This is the moment where the entire direction of the case changes. Campbell begins questioning whether he properly received and reviewed the indictment, bringing up concerns about the timing of the charges. While defendants absolutely have rights to understand the accusations against them, the judge is focused on keeping the hearing centered on the plea agreement that has already been negotiated. But then comes the reality check. Judge Raquel explains that she is not required to accept a plea agreement and reminds Campbell of the serious risk he faces if he decides to take the case to trial. The difference between accepting a negotiated deal and being convicted as a habitual offender can be enormous. This is something many people outside the legal world don't realize. A plea agreement is often a strategic decision where both sides weigh the risks. The defendant avoids the uncertainty of trial, and the state avoids spending resources proving its case before a jury. So what would you do in this situation? Would you take an 18-year agreement knowing the alternative could potentially be much longer, or would you fight the charges in court despite the risk?
So here's the
To
thing.
actually be honest, I just only been here for like about 30 days. So I got like 3 weeks or 30 days and about 2 weeks of being here.
Here's a picture
in both
one here.
Yeah.
So, the nature of the crime, no cause number, and the magistrate, as far as the indictment, I never received one. And due to the fact of the nature of the charge of being from 2018, you have 5 years or 4 years to indict me to actually send that indictment after.
Sir, the
That's
allegation,
why I'm pleading no contest.
I'm not going to
I'm
allow.
fine guilty. It's fine.
Here's the thing, I don't have to accept any plea agreement.
Yes, ma'am.
Okay, so you can, in that evading arrest or detention case, if you go to trial and you're found guilty, it's habitual. You're looking at 25 to life. We can set it for trial. I'm not playing games, and I'm not going to accept the disrespect. If you want me to follow this agreement and go along with the plea agreement, and you can go on, do your time and be done with it, then we can get that done. But you're not going to show disrespect while we're doing it to me. Do you understand?
Yes.
So if you want to go forward, we'll go forward. If not, we'll set it for trial. Mr. Smith will get ready very quickly, and we'll get your case tried within a month. And it'll be habitual 25 to life. What do you want to do?
It's 18 years.
No, the plea
If
agreement.
you go to trial, listen to me. If
Yep.
you go to trial and you're found guilty and your prior convictions, stop talking over me. If you go to trial and you're found guilty and those prior felony convictions are true, then you're looking at habitual 25 to life. Today, there's an agreement for something different. I'm glad to accept that if that's what you want to do, but you're going to either accept responsibility and plead guilty or plead not guilty.
Yeah.
That's your choices. So let's go back then and cause number 2136426. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty?
The judge has now laid out the situation in the clearest possible terms. There are only two choices in front of Campbell in this courtroom: plead guilty or plead not guilty. Yet the confusion over the prior conviction and the enhancement paragraph creates another heated exchange. Here's where legal terminology becomes incredibly important. The prior assault family violence conviction is not the same event as the evading arrest charge. Instead, it is being used as a prior conviction that affects the legal consequences and potential punishment associated with the current case. A lot of defendants who have experience with the criminal justice system believe they understand every detail of the process. But knowing some legal concepts and navigating an actual courtroom are two very different things. Raquel's job is to ensure the record is clear and that every plea is entered according to legal requirements. At this point, the biggest issue is no longer whether the paperwork exists. It's whether Campbell can move forward without continuing to argue every procedural step.
That's what I'm saying. You saying assault family violence. The evading arrest is I
Listen.
plead guilty.
It's evading arrest or detention with
But what
the
are you
use.
looking at? I'm saying
I'm
Look.
looking at your indictment.
He's saying you got indicted for
I got that.
evading. In 2014, you were
Hold on.
convicted
This,
of something
Mr.
else. Okay.
You've probably already tried. Let me take care of it this way. Give me just a second. Which one is being dismissed? 5-1 or
39051.
okay.
Make sure you don't get my information mixed up with him.
Who's?
Whoever that information is, I ain't gonna say his name on the record.
That's not you.
Just a second. It's taken care of. I should have 2 indictments. So just release. All right. Place that in front of your client, please. Now, that is cause number 2136426. That indictment alleges in paragraph 1 that you committed the third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020.
Yeah.
How do you plead to that charge?
I just pleaded no contest. She didn't want to accept no contest.
How do you plead to that charge? Guilty or not guilty? We're not going backwards, okay? I already told you you're not going to plead no contest.
Guilty or not? You plead guilty or not guilty?
So if I'm telling you no contest, what is that?
It's nothing, and it's nothing. You're not allowed. I can take a plea of no contest, or I cannot take a plea of no contest. That is up to the court. You're not legally entitled to plead no contest if there's a plea bargain. I'm telling you, if you want me to accept the plea agreement, you're going to plead guilty or not guilty. I've already told you that. I'm not going to tell you again. If I have to tell you again.
And this is where the frustration reaches a boiling point. Campbell continues insisting on a no contest plea, but the judge repeatedly explains that accepting that type of plea under this agreement is ultimately the court's decision. Courtrooms operate on procedure, and a hearing can't move forward when the same issue keeps being debated after the judge has already ruled on it. You can hear the tension rising with every exchange, and both sides become increasingly irritated. Then comes the emotional side of the situation. Campbell's comments suggest that he feels like pleading guilty is being forced upon him, while the judge insists that the choice remains his: accept the agreement under the stated terms or proceed to trial and face the potential consequences. This raises a fascinating debate. Is the judge simply enforcing the rules and trying to move the process along, or do you think there should have been more time spent explaining the defendant's concerns? Let us know what your opinion is in the comments.
Guilty or not guilty?
I'm saying.
Period. That's your. I'm
That's
about
saying
to
that
set
I'm
your
not-
case for
that's
trial.
saying that I'm not. That's basically saying that I'm.
We're not going to argue the
guilty,
law.
I'm not, or I'm guilty.
We're not arguing
That's
the law.
basically just saying that I
Doesn't-
state that.
I'm not going to
Go
argue
ahead.
the law
Fine,
with
no
you.
guilty. Just sign. Go ahead.
I don't-
That's guilty. Go ahead. That's what y'all want in you. That's
Listen.
fine. I'm cool, man. Just go ahead. and
Well,
get
you're
the
not.
guilty.
You're really not being cool, and you're making me very frustrated.
Ma'am, I respect your call. Just go ahead and give me the
It
guilty.
nothing here.
Plead guilty. There
Okay.
you go.
So you plead guilty to evading arrest or detention
Yes,
with
ma'am.
use of a vehicle. Okay. The next count, the next paragraph that you're looking at says that you were previously convicted of assault family violence December 5th of 2014. Is that true or not true that you have that conviction
That's
on
true.
your record? Okay.
And that's not the same
That's
case
okay.
as far as
Look.
evading arrest, man. That's two different charges. So if you really want to be technical as far as being a habitual, that's called a repeated offender. But
Exactly. And that's,
that.
listen, so Mr.
That's
Campbell,
15.
wow.
I think.
Do you want to come sit up here and be the judge? You're so smart.
I don't know. If you needed some help, man, I wouldn't mind.
I feel like I might because I'm not understanding.
The courtroom takes an unexpectedly sarcastic turn here. After Campbell suggests he might help the judge, she responds with humor and frustration, creating one of the most memorable moments of the entire hearing. But underneath the sarcasm is an important legal point. The judge explains the difference between being treated as a repeat offender under the agreement versus facing habitual offender consequences after a trial conviction. That distinction could literally mean the difference between a fixed sentence and the possibility of spending decades more behind bars. This moment also shows how courtroom personalities can impact the atmosphere of a hearing. Judges are expected to maintain order, and defendants have the right to ask questions. But when both sides become frustrated, the tension can become very obvious. The surprising part is that despite all of the arguments, the plea process continues moving forward.
Mr. Campbell, you're getting a deal to go on count one only, which makes you a repeat. I get that you've been through this before and you understand what's going on, but you're making this more difficult. If you go to trial, you could be habitual. Today, if we take this great plea agreement, it's repeat. I understand that. I've been doing this for 30 years. Okay? So, did you enter your plea of guilty freely and voluntarily?
Guilty.
Did anybody force you to plead guilty today?
Nope.
Okay. So I have well, let's go to the next case then. In cause number, and here's that indictment. In cause number 22-39050, you're charged with and in this case, we're just going on count one.
Count one only.
So in this case, we're going on count one only. So it's just the offense of tampering with physical evidence, a second-degree felony from November 28th of 2020. And how do you plead to that charge? Guilty or not guilty?
Pleading no content, but guilty now.
So are you pleading guilty to this charge?
Yeah.
Okay.
Unfortunately.
And did anybody force you to plead guilty in cause number 2239050?
We just answered it.
I know I have to ask you in each case. It's required by law. It's required by law that I ask you that in every case.
Just pleaded guilty.
Okay. And nobody forced you to do that, right? Speak up so the record can take
No,
account.
I think you did. You did, but that's good. So no.
Okay. So I have in both of those cases here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed those, did you go over them with Mr. Parker? The documents on the tablet, y'all have that? And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving any right to appeal? Yes or no, please. Do you understand that?
What we signed, documents.
Okay. You have to answer out loud, yes or no, so that the record's clear that you understand, that I know you understand what you signed. Okay. I'm not trying to, doesn't have to be that difficult. Just get in, get your deal, and get out. You're making this way more difficult than it has to be. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest could result in your deportation? If you're not a U.S. citizen, could result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
So what this is, sovereign.
I'm required to ask everyone that. Are you a U.S. citizen?
Yeah.
Okay.
Now the judge shifts into one of the most important parts of any guilty plea, making sure the defendant understands exactly what rights he is giving up. Many viewers may wonder why the judge keeps repeating similar questions. Why ask if anyone forced him to plead guilty multiple times? Why confirm his understanding again and again? The answer is simple: the court record matters. A guilty plea can have major consequences, including limits on appeals and other rights, so the judge must establish clearly that the decision was made knowingly and voluntarily. The immigration warning is another example of a standard legal requirement. Even though Campbell confirms he is a United States citizen, the judge is required to ask because a guilty plea can affect non-citizens in serious ways. These repeated questions may seem repetitive, but they are actually designed to protect the legal process and prevent future disputes about whether the plea was valid.
State tenders number 1 in each case. It's admitted in each case. Is there any evidence that Mr. Campbell is not competent?
No, you're
I just printed the wrong thing.
She asked me if I thought that there's evidence you weren't. I said, no, there's not. He's confident.
I just printed the wrong stuff. Did I print both of the certifications?
Thing on that shirt.
Okay. All right, Mr. Campbell, I'm going to find in each of your cases that you, Mr. Campbell, pay attention to me for a second, please.
Oh, foul, please. I ain't drinking.
Mr. Campbell. You ready?
Yeah.
In cause number 2136426, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
So can you say that on record?
I'm on the record.
No, I'm saying say that how long I've been in custody.
I don't know. I don't have that information.
5 years.
Okay, you'll get all the credit that you are entitled to get by law. And cause number 2239050, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of tampering with physical evidence. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
The final sentence reveals the outcome of this intense courtroom battle. Campbell receives 18 years on both cases, and those sentences will run concurrently, meaning he serves them at the same time rather than one after another. The agreement also includes the dismissal of another case and the waiver of his right to appeal as part of the negotiated plea. This ending highlights why plea negotiations can be so significant. Despite the arguments, interruptions, and moments where it seemed the hearing might completely fall apart, the original agreement was ultimately carried out. However, even after sentencing, Campbell remains focused on his jail credit, wanting confirmation of exactly how much time he has already accumulated toward his sentence. It's a reminder that for someone facing years behind bars, every single day counts.
These two cases will run concurrently, which means together at the same time and concurrently with any other sentence that you're currently serving. I have signed a dismissal as part of this agreement in cause number 2239051. I'm handing you in both of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with your attorney. You can go back with the bailiff.
So do I get my papers for my time, sir?
Go back with the bailiff.
Is you gonna bring me my papers for my time,
They
sir?
have it in the jail.
Excuse me?
They have it at the jail. I told you.
You didn't tell me.
Why wasn't that bad?
I mean, this one might be difficult, and Judge, this one's really gonna push you over the edge. Difficult.
Looking back at this courtroom confrontation, what started as a routine plea hearing became a dramatic lesson in how critical communication, courtroom procedure, and legal strategy can be. The judge had to balance patience with authority, repeatedly explaining the choices available while maintaining control over a defendant who constantly challenged the process. Campbell ultimately accepted the plea agreement and received 18-year concurrent sentences for evading arrest with a vehicle and tampering with physical evidence, while avoiding the much greater risk of a habitual offender sentence that could have resulted from a trial conviction. The hearing also showed why judges carefully ask repeated questions, review plea documents, and make sure every decision is entered voluntarily and on the record. Cases like this always create debate. Some viewers may feel Campbell was simply trying to protect his rights and understand every detail, while others may believe his repeated arguments made the process unnecessarily difficult. The question is, where do you stand? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe Zaini Say's Courtroom Cases for more jaw-dropping courtroom breakdowns.